Well, hello everyone, and welcome back to AJ507 Ethics in Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So we have a lot to cover in Chapter 9. That's going to be this week's chapter, and we're going to look at discretion and dilemmas in the legal profession. So we're going to now incorporate some additional players, if you will, into our lecture. So with that being said, a lot to cover. Let's go ahead and just jump right in. So some things that we want to learn. We want to be able to describe the ethical issues faced by defense attorneys. The same thing with number 2. We're going to describe the ethical issues faced by prosecutors. Describe some of the areas of forensic science that have been challenged by opponents. Describe some of the ethical issues faced by judges. And then look at how federal sentencing guidelines have changed because of Supreme Court decisions. And we know that, and if you've taken a criminal law class, you know that, the Supreme Court, some of their precedent cases truly impact policing, whether it's the court system, corrections, or law enforcement. So let's go ahead and jump right in. Okay, so if you remember back in Chapter 6, we described ethical dilemmas for law enforcement, police officers, as inevitable because of the discretion that they have in their job and in the role that they function in, right? They have a lot of discretion. Well, the same is true with legal professionals. And if we accept that discretion is basically a reality, an operating reality in the justice system, then we must ask in what ways legal professionals use this same discretion. So that's a very interesting question. So if individual value systems replace rules or laws, the resulting decisions may be ethical or unethical. And judges' rulings on things like evidentiary matters are supposed to be based on rules of evidence, but sometimes there's going to be room for interpretation or individual discretion. Now, kind of taking this just a little bit further, and talking a little bit about judges, there are a lot of other situations where one's biases and prejudices, may not be so easily identified. Again, judges' rulings on, things like evidence are supposed to be based on rules of evidence, but sometimes, again, there's room for, some individual discretion. And while most judges use this discretion appropriately, etc., and they make decisions, using their best effort to conform with the spirit of the rules, the evidentiary rules, other judges could and might use arbitrary or unfair criteria. They might dislike an attorney. They might not like a rule in particular. We've all kind of thought that, right? Where maybe even something at work, there's a rule that came out and we didn't like it. Or maybe an actual desire for one side to win over the other. But although the roles and duties of a defense attorney, prosecutor, and a judge are very different, what they all do have in common is that great deal of discretion, okay? So now let's kind of move forward and talk a little bit about ethical issues for defense attorneys. So due process, including notice, neutral fact finders, cross-examination, and presentation of evidence and witnesses, is supposed to minimize mistakes in judicial proceedings that might result in the deprivation, or it's going to affect, if you will, life, liberty, or property. Okay, and the defense attorney is there during the important steps of the process to really ensure that these rights are protected. So, for instance, defense attorneys, present during interrogation, can make sure no coercion is used. At lineups, they make sure that the identification is fair and unbiased. And during trial, they ensure that adequate cross-examination and presentation of evidence is brought forward, right? So you can see that they have an important role. So, and we just covered a few things. We covered, being present during interrogations, to make sure there's no coercion, lineups to make sure that, there's a fair identification process. And then during trial to make sure that they ask the right questions, right? They cross-examine witnesses, etc., and they present their own evidence. So, many defense attorneys in in private practice started out as prosecutors. And this sometimes causes problems when they have trouble making the transition, if you will, from, good guy battling evil, if you will, to the subtler role of defender of due process. And if the attorney cannot make that transition from prosecution to defense and feel, comfortable in the role, it's difficult to offer, a zealous defense, right? It kind of makes sense. So some argue that the system tends to operate under a presumption of guilt. Now, indeed, defense attorneys are often in the position of defending clients that they know are guilty, right? And that's kind of an interesting conversation that we're going to have. The rationale for defending a guilty person is that everyone deserves due process before finding of guilt and punishment. And if defense attorneys are doing their job, we can be more confident that the justice system has been served. And if they're not doing their job, we really don't have a system of justice, and none of us is safe from any type of wrongful prosecution, and the awesome power of the state to investigate, prosecute, and punish. So, kind of to summarize here, defense attorneys are often in that position of defending clients that they know are guilty. And with that, an attorney is supposed to assist clients without regard for personal preference or interest. And that's kind of tough, right? You don't really get to pick and choose your clients. If you have a private practice, you do. But if you work for a city, a county, etc., you don't. And, people with unpopular causes and individuals who are obviously guilty, they still, in the eyes of the law, deserve counsel. So it is the ethical duty of an attorney to provide such counsel, regardless of what I've basically just kind of covered. Now, there's a kind of interesting statute. So the American Bar Association has basically published, kind of a textbook or a guide, if you will, Criminal Justice Standards, the 4th edition. And, in this, it talks about a defense attorney's duty. So we're talking about the responsibility to a client, right? So a defense attorney's duty is to serve as the accused counselor and advocate with courage and devotion. Now, that could be tough, right? If you know that somebody's not being truthful. And we'll talk about some other things relating to that in a little bit. So an attorney, a lawyer, and we're still talking about responsibility, is supposed to provide legal assistance, again, to clients without regard for personal preference or interest. And once he or she takes the case, that being the attorney is not allowed to withdraw from the case unless some of the following things are met. So you can't accept the case, etc., and then just drop it because you don't like the way the person looks or you don't agree with whatever they're saying as far as, whether it's politics or anything, right? There has to be a criteria for that. So here is the criteria. Attorneys cannot abandon their clients, basically, okay, or withdraw, unless, one, the legal action is for harassment or basically malicious purposes. 2, continued employment will result in violation of a disciplinary rule. 3, if discharged by the client, meaning the client basically fires you, they don't want you to represent them anymore. Or finally, 4, a mental or physical condition renders effective counsel impossible. Now, in other cases, a judge may grant permission to withdraw when the client insists on, illegal or unethical actions, is uncooperative and doesn't follow the attorney's advice, or otherwise makes effective counsel difficult. Okay, but in general, judges, are, they really do kind of know what's going on. Okay, but they can also remove an attorney from a case based on what I just said right there. Now, a more recent issue has emerged with the rise of what we call specialty courts. And, in such courts, defense attorneys, prosecutors, and judges take on kind of a different role from the more typical adversarial approach in a regular criminal courtroom. Adversarial is kind of how the basis of the court systems run. You have one side being the defense, one side being the prosecution, and there's an adverse thing there, right? There's one side against the other, and in the hopes that when each side presents their case, all of the issues come out, and then the jury gets to decide, or the judge gets to decide on those issues because everything is brought forward. Okay, so that's kind of the rationale for the adversarial part. So, here with these kind of specialty courts, if you will, there's an emphasis placed on the actors as a team, and the judge, basically it kind of has a different role. Interacting with the defendant, monitoring progress, etc. So kind of some different things. So in these courts, the defense attorneys, appear most redundant, since the court's goal is to do what's best for the client and the defendant. And there's a case there. So in fact, there's a case, Meekins, in 2007 argues that defense attorneys face sensitive and serious ethical challenges in these specialty courts, if you will, because they should not forget their primary responsibility is to the client, even if it means arguing against treatment. So in these specialty courts, it could be a drug court or something similar. You're doing what's best. Everybody, all the actors are working together to do the best they can for a client, and that could be maybe going to some type of drug treatment or rehab or anger management or domestic violence or whatever they're working to get you to go to, right? To get their client to go to, and everybody's on the same page. And that's kind of contrary, is what they're saying, to the defense attorney's actual role, which is arguing for their client, which could mean arguing against treatment. So you can see how it's a little different, right? So these are things that we have to kind of really understand. But these specialty courts are kind of an interesting thing. So again, in these courts, there's a tendency for defense attorneys to influence clients to accept treatment, where the client must plead guilty in order to get the treatment. Instead of defending them and saying, don't plead guilty, let's fight this to the end because you're innocent, etc., a lot of times they may have to segue into trying to influence their client to plead guilty because that's how they get the treatment. So again, there's just some things for us to kind of consider when we talk about these specialty courts, if you will. And kind of along those same lines would be things that we call conflicts of interest. So attorneys must not represent clients whose interests conflict with those of the attorney. and attorneys must not represent two clients with opposing interests. So there's a lot more to it, right? And if a heavy caseload compels an attorney to advise his or her client to accept a plea bargain instead of going to trial, the question here is, has the attorney violated prohibitions against the conflict of interest? And we're going to talk about plea bargaining as we go a little bit kind of further along, okay? But remember, the defense attorney's job is to fight for their client. But in the specialty courts, they may have to convince their client to plead guilty to get the treatment they need. But we also have to consider the different conflicts of interest that kind of fall in line with everything too. Okay, so with that being said, now we're going to talk a little bit about plea bargaining. Now, your textbook defines it very short. Basically, exchange of a guilty plea for a reduced charge or sentence. Now, most cases in the criminal justice system are settled by plea bargain. Okay, so don't let this fool you. Not every case goes to trial, because there wouldn't be enough time in the day, week, month, year, etc. to have every case go to trial. And there are some good reasons for plea bargaining as well. And plea bargain, again, is an exchange of a guilty plea for a reduced charge or a sentence. Okay. And you can see by the little picture there, plea agreements are common because a defendant can reduce the risk by pleading guilty to fewer or less serious charges, or negotiate agreements to reduce the possible prison sentence. So, and there's other rationales for plea bargain as well. Now, the defense attorney's goal in plea bargaining is to get the best possible deal for the defendant, right? And the defense attorney is aware that he or she cannot aggressively push every case without endangering the ongoing relationship with the prosecutor. So that's one thing to consider, that there is a relationship between prosecutors and defense attorneys, and a lot of times they do engage in plea bargaining. And it could be because either side doesn't have a very good case, and they want to plead it out. It could be that maybe it's a first-time offender, and they want to bargain for a lower sentence or a lower charge. It could be that there's 3 or 4 charges, and in order to save the court's time, the individual could plead guilty to a couple of them, but not all of them. So you're talking about court time, court costs, taxes, the length of time somebody has to stay in jail. There's a lot of things that come to plea bargaining, but it can also not be a good thing. You could be pressured into taking a plea bargain, right? So, but again, understand that there is a relationship with the prosecutor, and that's really important to understand. So, how does the prosecutor or the defense? Let's start with the defense, and let's talk a little bit about zealous defense. So, you've heard me say it a couple of times: zealously defend. So, defense counsel must zealously, vigorously, with the best they can, the best of their ability, proactively defend their client, but not commit unethical acts to do so, right? So, I think few would challenge the idea that all people deserve to have their due process rights protected, right? However, many people find, kind of unsettling is the zeal in which some defense attorneys approach the courtroom trial, if you will. And so how diligent should the defense be in protecting a defendant's rights? Well, again, remember, a conflict may arise between providing an effective defense and maintaining those professional ethics and individual morality. Lawyers should represent clients, as I said, zealously, with the bounds of the law, within the bounds of the law. But the law is sometimes vague and difficult to determine. So, what should counsel not do? What are some ethical standards and rules, things that are forbidden, if you will, some of the actions? So here, the lawyers, basically the attorneys, may not engage in motions or actions to intentionally and maliciously harm others, knowingly advance unwarranted claims or defenses, conceal or fail to disclose that which he or she is required by law to reveal. Maybe not, they might have some evidence, but they're not going to reveal it. Knowingly use perjured, that means lying, okay, untrue, false, testimony or false evidence. Knowingly make a false statement of law or fact. Participate in the creation or preservation of evidence when the attorney, he or she, knows or it is obvious that the evidence is false. Counsel the client in conduct that is illegal. Or finally, engage in other types of illegal conduct. So there's kind of a lot there, right? And again, these are ethical standards and rules that attorneys have to basically follow, if you will. Now, the attorney is also expected to maintain a professional and courteous relationship, again, with the opposing attorneys, litigants, and witnesses, and to refrain from disparaging statements or badgering conduct. Okay, so there are some other kind of aspects that come into play here. The defense attorney must not intimidate or otherwise influence the jury or the trier of fact, that's the jury, or use the media for these purposes. Okay, and kind of going on further. Now, despite these ethical rules, practices such as withholding evidence, manufacturing evidence, witness badgering, defamation of victim's character are sometimes still used as tactics in the defense attorney's arsenal, if you will, right? So, aggressive advocacy sometimes involves the use of these questionable tactics that I kind of talked about, right? And again, it could be manufacturing evidence, witness badgering. An example here could be bringing up the sexual history of a rape victim. Okay, and they could bring that up in such a negative light that it really defames, if you will, the victim in the case. Attacking the credibility of someone they know that's an honest witness. So part of their job as a defense attorney is to defend their client, and sometimes attorneys can walk that very fine line, right? And some of the tactics that they use can be very questionable, if that kind of makes sense. Attorneys, again, well, let's do this. Most ethical conflicts really arise over subtle questions of how far one should go to provide that zealous defense. And it is sometimes difficult to determine when a defense attorney's treatment of a witness is badgering as opposed to maybe an energetic, right, or just emotional cross-examination, or when exploring a witness's background is character assassination as opposed to a careful examination of somebody's truthfulness or credibility. So you can see there's a fine line there, right? And that's kind of what they're trying to say here. Other things like whispering during opposing counsel's opening or closing, statements, rolling one's eyes in response to a statement or question, or making other verbal or physical gestures indicating disbelief, amusement, or even disdain are part of the arsenal of a trial attorney. And they are considered by some to be fair and within the rules of the game, and they're considered not to be fair by others. So again, it's how far can you go with that zealous defense? Now let's talk a little bit about jury consultants. And this is actually super interesting if you've ever watched the show Bull. Kind of a really cool show, actually. So attorneys often contend with, a trial that's been won or lost once they have selected the jury. And whether it's true or not, attorneys are increasingly using psychologists and other experts to help them choose which members of the jury panel, if you will, would make up good jurors, right? Who would fit the best with your case. And this TV show Bull is a pretty cool example of watching that. You know, a good juror for a defense attorney or prosecutor, of course, is not someone who is unbiased and fair, but rather someone who is basically predisposed to be sympathetic to that attorney's case, right? They've already kind of got their mind made up. And jury experts, you know, through a combination of nonverbal and verbal clues, identify those jury panel members who have that predisposition or who are predisposed to believe that the case presented by the, believe that particular case presented by the attorney. So it's kind of an interesting thing. And that kind of moves us to a term that you probably should remember, and that's called a shadow jury. And some of you may have heard of this, and some of you, maybe you haven't. So another method of, kind of jury selection or looking at how to win a case, etc., uses what they call a shadow jury. And this is a panel of people selected by the defense attorney to represent the actual jury. And the shadow jury sits through the trial and provides feedback to the attorney on the evidence being presented during the trial. And this allows the attorney to adjust his or her tactics during the trial in response to what members of the shadow jury are telling the attorney, right? So it's kind of, interesting. And attorneys really have always used intuition and less sophisticated means to decide which jury members to exclude. But the more modern tactics are questioned by some as too contrary to that basic idea that a trial is supposed to start with a unbiased jury, right? And, these jury consultants also provide other information or do other things. They do witness prep. So they prepare the witness. They assist in what we call a mock trial. They developed desirable juror profiles. They conduct phone surveys on public attitudes about a particular case. They analyze the data provided by the shadow jury, and they give advice on effective posture, clothing choice, tone of voice. How do I testify? What should I look like? What can I say? What can I not say? Kind of interesting, right? So, can our ethical system help determine what actions are ethically justified in defending a client's, a client zealously? That's a super interesting question, and we'll talk more in other chapters. Okay, some other things that kind of fall into the area of discretion and dilemmas would be that of confidentiality. So the attorney-client privilege refers to the inability of authorities to compel an attorney through subpoena or threat of contempt, etc., to disclose confidential information regarding his or her client. And the ethical duty of confidentiality prohibits an attorney from disclosing to any person or using for one's own gain information about that attorney's particular client obtained through the attorney-client relationship. And any attorney who breaches that confidentiality could basically be disbarred. So it really is a big deal. And there are other types of, there's religious confidentiality. We're talking more of attorney-client, but, another one could be, a parishioner to their priest, etc. There's some confidentiality in there as well. But remember the phrase attorney-client privilege, because that's really, really important information. And kind of keep going with this. Confidentiality is inherent in that relationship between the client and the attorney, But more important is that the client must be able to expect and receive the full and complete assistance of the attorney. So not only do they have to keep that attorney-client privilege, but they also have to, you know, they're going to expect that the attorney will do everything they can in their power. Now, parallels to the attorney-client relationship are relationships between, let's say, husband and wife. We talked about that, or priest and penitent, one who repents, etc. So if you go in and repent to your priest, that would be a kind of similar, if you will, or a parallel to attorney-client privilege. Same with the doctor, etc. So those are other types of, confidentiality that you might run across. Now, with that being said, what then are some exceptions that allow, that permit you to reveal something that you might be told in confidence? Well, when the client consents, so they give you permission to do it, when it's required by law or court order, to defend against an accusation of wrongful conduct, to prevent clients from committing crimes or fraud, to prevent, mitigate, or rectify financial injury to another individual. And those are just a few. Now, one of the most debated portions of this has been the part of this rule that specifies what type of crime justifies divulging confidence of a client. So how high, where does that crime have to be, if you will, in order for you to be okay to tell somebody, right? So that's kind of an interesting thing. Well, the model code, used before the model rules, allowed disclosure to prevent any crime. An earlier version of the model rules basically dictated that an attorney could ethically violate a client's confidence only to prevent a future crime involving imminent death or basically great bodily harm. And many state bar associations refused to adopt the restrictive rule or enlarged it to include any crime. Now, the current version, requires disclosure of financial crimes if there is substantial injury, but it also allows disclosure to mitigate or rectify a financial crime. So, and it should also be, kind of noted that the rule of confidentiality does not apply to physical evidence. So, and try to follow me here for a second. Anything that is discoverable in the possession of a client is equally discoverable if in the possession of an attorney. Therefore, an attorney must hand over files or other incriminating evidence subject to a valid search warrant, motion, or subpoena. If the attorney is merely told, let's say, where these physical evidence may be found, they're not obligated to tell the authorities where they are. So if they have it with them, they're required to give it up. If they don't have it, but let's say their client told them where it is, and they don't possess it, then they're not required to say anything, right? So here's an example. If a client tells an attorney that the murder weapon is in a certain location, the attorney can't divulge that information. However, if the client drops off the murder weapon in the attorney's lap, the attorney runs the risk of being charged with a felony if it's hidden or withheld from police. That kind of makes sense? So possession really is kind of like the big thing here. Okay, we'll talk a little bit more about, and the confidentiality rule. So, the confidentiality rule seems to be justified by, utilitarianism, because society benefits in the long run from the presence of, attorney-client confidence. Therefore, this confidence should be sacrificed only when it endangers a life, which would be a greater loss than, the benefit of the client or that, the attorney, the trust. And again, the rule of confidentiality doesn't apply to physical evidence. Anything discoverable in the possession of a client is equally discoverable if in possession of the attorney. Okay, so a lot of rules, right? And a lot of different stuff. And there's a super interesting case that if we have time, I think I'll come back to. And we'll talk a little bit about it. But I provided you a link there, and it's the buried bodies case. And this really does kind of, I think you'll find it interesting, but it talks a little bit more about the ethical dilemmas as it relates to kind of the attorney-client issues. All right, so read that, take a look at it, and maybe we'll talk a little bit more about it at a different time. All right, so now we're going to talk a little bit about perjury, and then we'll take our first break here pretty quick. So defense counsel should not knowingly offer false evidence. Okay, and a defense attorney's ethics may also be compromised when a client insists on, taking the stand to commit perjury. And perjury is the intentional act of swearing a false oath or falsifying an affirmation to tell the truth, whether spoken or in writing, concerning matters material to an official proceeding. And I put the actual, you can click on here, it'll take you to the California Penal Code section, which is 118. But that's the reason when somebody gets up to testify, you see, raise your right hand, you raise your hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Yes, I do. That's the oath or affirmation. And you are swearing in an open court in front of the judge and jury that you are going to tell the truth. And if you get caught lying, that's a felony and that's perjury. And it's the same thing with a search warrant. Even if an officer or investigator goes into a judge's chamber, and you don't do this in front of everybody, you go into the judge's chamber with your search warrant, before you sign the warrant, the judge has you raise your hand and you swear that everything in the affidavit in the warrant is correct. Because if you intentionally lie, you can be held responsible for that. And again, that's part. That's what the oath or affirmation part really kind of points out. So again, defense counsel should not knowingly offer false evidence. Okay. A defense attorney's ethics may also be compromised when a client insists on taking the stand to commit perjury. And if the client persists in their plans to lie, the attorney can then, and really does have an ethical duty to withdraw from the case. Now, here's the gray area, okay? If the attorney is not sure that the client would be committing perjury, there's no legal duty to disclose. So you could see that's a little bit of a gray area, right? So yeah, I mean, that's very, very gray to me. Because couldn't the attorney just say, well, I wasn't sure. So again, that's the ethical part. Okay, so if they know that their client and they persist that they're going to lie, etc., they can withdraw from the case, or they have an ethical duty to do that. But if they're really not sure if their client would be committing perjury, then they don't have to. And Pellicati in 1990 explained that an attorney should first try to basically talk their client out of it, right? Dissuade them from committing perjury. And again, if the client plans to lie, the attorney then has an ethical obligation to back out or withdraw from that case. And then this, of course, will jeopardize the case, and disclosure is even more problematic because arguably it will affect the judgment of the hearing judge. And there's a couple of cases that go along with this. One is Nix versus Whiteside in 1986. And you can take a look at that at your leisure if you would like to. So kind of talking a little bit more about what Pellicati described, and then we'll take our break. So, Pellicati, still in 1990, basically describes the passive role and the active role of an attorney with a client who commits perjury. And in the passive role, the attorney asks no questions during direct examination that would elicit an untruthful answer, and may make a statement that the client is taking the stand against the advice of their attorney. And the attorney does not refer to perjured testimony during the summation or any arguments. Now, the active role allows for the attorney to disclose to the court the fact that that there's perjured testimony, and there is no great weight of authority to command either approach, leaving attorneys with a kind of a difficult ethical dilemma, right? The best defense of some attorneys is not to know about the lie in the first place. And if the attorney is not sure that the client would be committing perjury again, there's no legal duty to disclose. So, when you kind of think about it, if the attorney puts the client on the stand, they know they're going to lie, but they don't ask them any questions that elicit the lie. Is that really unethical? So that's kind of the difference between the passive and the active approach as it relates to perjury. And I hope you can see some of the gray areas there as well. And keep in mind, the ethical issues for defense attorneys, again, revolve around being an advocate for the client, right? While at the same time performing as an officer of the court, because they are officers of the court. And that zealous defense within the bounds of the law, again, is the primary duty of a defense attorney. Okay, so this would be a really good time. We'll take our first break right now. We're right about 41 minutes, and then we'll come back for part two.